Studies Institute, my lords, justices and judges and courts of education, the representative of UN Women, your worships, President of the Uganda Law Society, distinguished guests, ladies and gentlemen. It gives me great pleasure once again to come here and be associated with this work. As Justice Lotema already indicated, I was here a few months ago at the validation workshop. So at this rate, I will consider myself part of this. I also want to take this opportunity, at the earliest opportunity, to welcome His Excellency the Ambassador Designate of Sweden to Uganda. I do this on behalf of myself, the judiciary, and Jealous. We had a nice dinner last Thursday at my residence, where we had development partners as well as Jealous committee, and Sweden was represented by the Chargé d'Affaires, because we were told you were coming in 2 days later, and now 2 days later I'm meeting you for the first time. I will tell you, we have had a very cordial and very fruitful working relationship with Sweden in these matters, and I hope this will continue. This French book is a product of a series of consultations that involved a number of judicial actors and other stakeholders in the justice system in Uganda, with the support of UN Women. Let me therefore begin by thanking everyone who has made a contribution to this project. Special thanks go to UN Women, the funders, and Honorable Justice David Lotema, the lead consultant of the project. I think everybody could see that he was inside himself with joy. If one had a stethoscope to his heart, I'm sure his heartbeat would be faster than that of a dove. As you may recall, as part of the consultation process, a validation workshop was held in June 2016, on which occasion the final draft of the bench book was reviewed by members of the bench and other key stakeholders who provided technical input to the bench book. The bench book we are launching now is therefore not new to many of us. Matters of human rights, the rule of law, and access to justice are central to our work in the justice law and order sector. We are concerned about every person's access to justice and their full and unfettered participation in the judicial processes. One of the major impediments of access to justice, however, is vulnerability, particularly due to discrimination. Gender-based discrimination ranks high on the list of causes for vulnerability. It is without doubt that women often find it more difficult than men to access justice. But let's be clear on this. It's not that the ordinary man in the village has unfettered access to our system. They all have that disability. But women are even more so because of the social inhibitions and cultural activities that Justice Martin was talking about. This has been attributed to discriminatory laws, norms, and practices within the various societies in which we live, coupled with lack of awareness on the part of the various actors within the justice sector, the women themselves, and the general public. The above notion is not without evidence. The justice law and order sector, JELOS, conducted a study in May 2011, which showed, among other things, the limited capacity of the judiciary to deliver gender-sensitive justice to the general population of Uganda, but more specifically for women. The study further revealed that although a number of trainings had been conducted for judicial officers on gender justice, some of the court procedures and judgments clearly demonstrated their inability to translate the gender training into concrete benefits for women. The major reason identified for this gap was the absence of tools for the judiciary to use in making the court processes and judgments more gender sensitive. As an intervention, a number of tools were identified and recommended to free data. One of them is the development of bench briefs for judicial officers to use and refer to in their adjudication cases. The gender bench briefs were intended to avail to the bench local and international best practices, to be used as persuasive authorities by court officials in determining cases whether gender issues and particular women's rights are involved, and to assist judicial officers in addressing procedural issues that impede access to justice. This is how this bench book comes in. I think the example given to us by Justice Martin of the lady coming to his court late and the interest of justice in dismissing her case is a very good illustration of how we have been proceeding. The bench book should be viewed as an essential tool for the achievement of real access to justice on the part of women. When women are faced with situations of discrimination or violence, as they often are, their only recourse are law and justice agencies. The biggest disappointment, therefore, is if the justice agencies are themselves inaccessible or unresponsive to their plight. This is what breeds impunity and systematic abuse of the rights of the vulnerable woman. Unfettered access to justice for women is therefore a cardinal human rights issue. Remember, there is a provision in the Constitution about fair hearing not being a non-derogable right. So if the fellow is denied even access in the first place, then you can see she's suffering double jeopardy. No access, and even when there is access, the Latimas will tell her, sorry, you are late for work. The value of a bench book is that it breaks down the complex and often abstract legal norms, not only for judicial officers. Singular honor and privilege to launch the gender-proof bench book on women's access to justice in Uganda.
My Lord, the Chief Justice, we thank you for launching. We request you to sign a few copies if you will present it.
Legal practitioners. It assists the core users in overcoming latent gender stereotyping, which normally locks the mind of judicial officers and impedes them from delivering gender-balanced decisions. In that regard, therefore, the bench book is expected to strengthen the jurisprudence of equality on women's access to justice in Uganda, to provide current and cutting-edge case laws on gender issues, and to assist in developing effective judicial strategies through benchmarking along global practices and experiences. Despite the existence of elaborate legal provisions and jurisprudence on gender equality, the critical challenge that remains is the interpretation and enforcement of these laws so as to ensure effective access to justice for women. To be able to effectively do this, the key stakeholders need to do more than the ordinary interpretation of the law. This calls for the adaptation of modern working tools and methods. A bench book such as this is one of such tools. If well used, the bench book has capacity to trigger judicial activism to unprecedented levels. These are the type of cases where a judicial officer should go beyond merely interpreting the law within the limitation of legislation and precedent, and focus his or her legal lenses to the broader, purposive, and liberal interpretation of the law, taking into consideration the extent to which it advances human rights, improves social justice, or equality, and enhances constitutionalism and the rule of law. This is what we need in order to realize effective access to justice for women. Sometimes some of these practices do come to our courts. Think of the case that came to court some time ago. I don't even remember the decision, but a lady, a mature lady, an adult, meets a young man. And they date, they want to get married. She comes to introduce her fiancé to her parents. Then the father said, but you belong in the same clan, so you can't get married. Now, there is no blood relation between those two people. It's not within the prohibited, the reason for possibility written in the law. But the father says you can't get married. And he goes to court and gets a decision. Now, what's the rights of that adult woman exercising her freedom under the Constitution and she's above 18 to get married? Would you say that that custom which says you can't marry someone of the similar totem is against the dignity and rights of women? I don't know. And indeed, even in some of these things that we are condemning, things like